Welcome back. So we're listening live to testimony from a witness, and this is in the case of Tennessee versus Tremaine Wilbourn. This is the one that's accused of shooting and killing the officer who had 8 gunshot wounds. Now, what's interesting is this testimony, she specifically said that the defendant's back was to her and that she did not see the shooting. So I have 2 special guests I'm very happy about today. Misty Marris is with us. She is a law and crime legal analyst and also a trial attorney. Thank you for joining us today.
Thanks, Ashley.
And Latonia Hines is also here. She is a former defense attorney, current prosecutor. So I'd like to turn our attention to this particular witness and the fact that the testimony was, hey, I didn't actually see him shoot. How much is that going to affect this witness's usefulness to the prosecution? And let me start with you, Misty, if I could.
Sure. So for the prosecution's perspective, they just want people that can be there, that can put the defendant at the scene of the crime, that can explain the circumstances surrounding what happens. Obviously, it's all coming down to those few minutes where the defendant and the police officer were interacting. Now, from a defense perspective, that is where the focus is going to be on raising that reasonable doubt. So you did not see the actual shooting. Your back was turned. You don't really know what happened in those moments, those critical moments that are going to be the linchpin in whether or not there's a conviction or something else.
So, Latonia, let me turn to you and ask you this. Why present this witness as the prosecution? Because the reality is they had previous testimony yesterday by someone who did say, yes, I saw the defendant shoot the police officer. So having that witness, why have this witness testify today when she didn't see the shooting?
She didn't see the shooting, but she heard it. And that is something that's significant. And here's what we've got to realize, too. The defense already has an uphill battle because the main thing is he's already admitted to being there. You know he was there. He leaves there. He goes and carjacks someone else. What the defense attorneys are trying to do in this case, they're not trying to save the conviction. They're trying to save him from the death penalty. I think that's what they're working on more so than anything, because you have a lot of instances and a lot of information that shows he was actually there. And I think for the prosecution, it's showing he didn't stop at all when he shot. When you look at, especially when you get into the medical evidence that's going to come in, he didn't shoot just one time. He shot about 8 different times. And I think that's why it's important, showing somebody who not only, she may not be able to identify the defendant. We know the defendant was there, but she can identify how many times she heard a gunshot.
All right, so stay tuned. We're going to return to that trial live after this short break. Welcome back, and we are covering live the trial of Iowa versus Tremaine Wilbourn. We don't know yet whether they're going to call another witness right now or not, so we're going to talk for a few minutes. But also, I want to give you a reminder to look online if you want to follow the case of Keene, and that is the father accused of murdering his 4-month-old along with his wife, the mother of the child, who is going to be tried separately at another time. So returning to my guests, Misty and Latonia, let's talk about the death penalty in this case. So specifically, they are asking for the death penalty if they do obtain a conviction of murder in the first degree. And there are 3 different things that they would have to prove, the state. And I want to talk about one of these. Number 1, that it was an officer on duty. Sounds like that's pretty straightforward to prove. Number 2, a previous felony conviction for an act of violence. He was previously convicted for federal crime robbing a bank and served 10 years previously. The third element is killing to avoid arrest, and that's why he committed the killing. So let's start, Latonia, with you first. Do you think the state in this case is going to be able to prove that he actually intended to kill the officer in order to avoid arrest?
Well, I think what the state's burden is going to be is showing that he knew that he was doing something illegal and that this officer in the encounter would have discovered it. And that was the reason why he needed to get rid of the officer and keep moving. Especially when you see the fact that he not only, after shooting this officer multiple times, he goes on to carjack someone further along. He continues his ongoing series of illegal acts. And I think the prosecution just has to hammer on the fact, I think there's some marijuana involved, hammer on the fact that he knew that this officer was going to probably arrest him, and this is why he had to get out of here.
All right, Misty, so do you agree, and what would your defense be if you were the criminal defense attorney in this case?
When it comes down to the penalty phase of a trial, when you have a death penalty case, the critical question is always mitigating versus aggravating factors. So the points that you both made all are aggravating factors. Right now, the defense is weaving through the guilt phase of the trial all of these issues that they're going to intend to raise that's going to seek to mitigate these issues and looking to save their client's life. So that's where the defense is going to go. That's why you're going to see a focus on you didn't actually see it, that there was no intent to actually kill the officer. That, while relevant for the guilt phase, will also be relevant for the penalty phase.
All right, so stay tuned for that trial. Right now, though, we're going to switch gears and go to the Iowa versus Keene. And again, this is the father of a 4-month-old accused of first-degree murder, child endangerment of that 4-month-old. It's a pretty horrific case and difficult factually to hear, but very important to know exactly what happened and what's going on in this trial. So we're going to return live to that trial now. Well, that was some almost bombshell testimony. You just heard Dr. Klein, who was the medical examiner of the 4-month-old, testify that, yes, it was in fact possible that that baby died on the day the baby was found. Now, keep in mind, previous testimony was that the father, who's on trial for this death right now, actually called 911 and said, I fed the baby this morning, he was fine. So, Latonia, let me turn to you first as my special guest, Latonia Hines, who's joining us from Atlanta. What significance does it have that now this medical examiner said, hey, this baby may have actually died today, the day the baby was found?
Then there's some doubt as to whether or not the father is truly the person responsible for the child's death. The date and cause of death, that's a really huge deal with regard to this timeline. All it takes is a little bit of doubt as to whether or not the father is truly connected when the child died. And I think that's kind of significant. I wasn't expecting that testimony today.
Right. So, Misty, let me ask you as one of our special guests today, tell me this. Do you think that the defense is going to argue or use that, hey, it could be true that he did go in to feed this baby a bottle and it was all good and well, and then look what happened, it wasn't his fault?
Certainly that's where the defense is going to go, and that's why this case primarily focuses on that medical testimony, the expert testimony, and the evidence of what the cause of death was and when somebody should have known there was a problem. So for the purpose of this particular trial, for this defendant, the father, let's not forget the postpartum depression of the mother is going to be part of his defense too. So in a case like this, it's murder by failure to act. A little different than cases we generally see. So anything that the defense can do to show that the timeline that he's reporting is accurate, for instance, this medical testimony, they're going to use that, and that's how they're going to raise that reasonable doubt.
Okay, but let's talk about the postpartum defense. If, in fact, that's what the defense raises, devil's advocate, shouldn't it not matter that maybe he didn't actively do anything as a result of not actively doing anything? Arguably, this child died. Isn't that enough for a conviction, possibly of first-degree murder? Let me start with you, Misty.
Certainly, it can be, and it all depends. First of all, the postpartum defense for the father, to me, is problematic right out the get-go. I'm a little surprised if the court lets that in because it's the postpartum of the mother, the suffering of the mother from this issue that it's relevant to. But essentially where the defense is going, they're going to say, well, the father thought the mother was the caretaker of the baby and that she was taking care of him, but she wasn't because of postpartum depression. As you pointed out, if he knew or should have known, and in this particular situation, there's a lot to go on with respect to some of the other medical testimony we've heard that this baby was in danger. His failure to act could also be a murder conviction.
So, Latonia, let's talk a little bit about everything that the jury is seeing and hearing during this trial. So at the same time that medical testimony was being provided, I have information about what was happening off camera. The defendant, apparently, while they were showing pictures, was looking at the screen. His lawyer then whispered something in his ear, and you saw him in part of the live trial we showed. He put his head down in his hand. So, Latonia, number one, any ideas as to what the attorney might have whispered to him? And number two, how much does that impact a jury listening to this case?
I mean, it's multiple things. Maybe the defense attorney's like, there's about ready to be some pictures that are going to be very upsetting and you may not want to see this, put your head down, or maybe even show them to have some emotions. The jurors watch everything. They watch the attorneys, they watch the defendant most especially. And here's the issue in this case. You've got two charges. You've got this first-degree murder, and then you've got this child endangerment. To me, even though you've got the timeline of death that's important, how does the father get around the fact that the medical evidence is going to show this child had maggots in this child with regards to feces and all this other stuff in various stages of development? For over a week, this child hadn't been changed. How do you get around that the father should have known that this child had lacked so much care? It's huge. That's huge. And I think that's why the jurors are going to be watching every aspect of how he thinks.
I didn't mean to interrupt you, Latonia, but let me add to that. Defense's opening statement that, again, was shown live here on Law and Crime. And part of it I thought was really effective, because what the defense basically said is, yes, this is a horrible case, a lot of emotions, but jurors, I'm asking you to put that aside, to keep an open mind, and to listen to the evidence, which is, in fact, obviously what any juror is supposed to do when they sit for a trial. So what defense do you think they're possibly going to raise when that's all they've said? Do you think they're evaluating the evidence as they go to figure out their defense? What's their plan?
Absolutely. Absolutely. And I think that was probably one of the smartest things that they did. So they didn't put themselves in a corner. They want to see how the prosecution's case develops to help them develop. And as you know, a defense can do their own opening statement. They can reserve, they can start another opening statement they want to at the beginning of their own case. And so this helps them, because ultimately the burden is on the prosecution to prove all the charges and all the elements of the charges. So it was probably best for them not to go in with a huge defense, because it's very hard to defend the stage that the child was in.
Thank you. And so, Misty, one last question for you before we go to a break, and that is, what do you think is going to come of the fact that there is alleged drug use? How does that play into whether or not he intended to kill this baby?
Well, certainly, drug use isn't an affirmative defense. You can't say, oops, I was on drugs and I did something I didn't mean to do, but it can negate intent if somebody's intoxicated at the time. In a case like this, what the defense attorney is going to look for is getting out of a murder conviction. So with that, it might mean falling on the sword with respect to child endangerment or some lesser included offense. And I think that what you were talking about before with respect to the opening statement was a brilliant choice by the defense under this situation, because, hey, look, they haven't locked themselves in to a theory of the case. They're waiting to see where the prosecution's going, and then they're going to poke holes that way throughout the course of the testimony and in their closing arguments. So I think the defense is probably anticipating there's a conviction on something, but hopefully not the murder charge.
And that's what I love about Law and Crime. I'm such a trial nerd. And so the fact and all the thoughts that go into the defense's mind on how to best present a case and how to represent their client zealously, even when they're horrific charges like these. Please come back. We're going to take a short break. Welcome back to Law and Crime. We are covering two trials live today. So let's start with Iowa versus Zachary Cain. This is the case in which the father is accused of murdering his 4-month-old, along with the wife, who will be tried later after this trial completes. And in this case, they are taking a lunch break. It will resume at 2 p.m., so we will continue to cover that after it resumes at 2 p.m. Now, the other case we've been covering today is the Tennessee versus Tremaine Wilbourn, and this is the defendant charged with shooting and killing an officer who is the victim of the crime on August 1st of 2015 in Memphis, and that was Sean Bolton as the victim in that case, and they are calling their next witness. But while we wait for that next witness to take the stand, I'd like to have a couple more questions with our esteemed guests today. First, we have Misty, who is here from New York trial attorney. We're happy to have you on air with us today.
Thank you.
So talk to me on the Wilbourn case, again, the one who killed the officer Bolton. How important is it to talk about what he was doing in the car, why the car was parked there? It was parked the wrong direction, which is why the police officer even approached it in the first place. But how much do those little details weigh into a conviction for murder in the first degree?
From a defense perspective, all of that is going to be important, and here's why. This case is coming down to one major issue. Did he shoot the officer to resist arrest. And that's really going to be the crux of the defense's, or the prosecution's case. They're going to say he was resisting arrest and that's why he shot this officer. From the defense perspective, they're going to say he did not intend to kill the officer, which to me, not such a great defense, but you got to work with whatever you have. And I would anticipate they would take a self-defense point of view. So if the defense can make a reasonable argument that there was not this illegal activity, that the officer's response was too severe, I think that's how they're going to play it to a jury to explain why their client's reaction was to kill, was to shoot a gun, which they concede he had illegally.
Right.
So where else are they going to go other than that direction?
Right. They even said that in the opening statement. So we're going to return to the Wilbourn trial right now live. They've just called another witness. So we see in that trial the attorneys are up at the bench having a conference with the judge. We're going to return to that trial once they come back live with us. But I do want to ask our guest, Latonia, I'm going to start with you because we ended with a point that Misty made that I really want to focus on. How can defense possibly argue when 11 shots were fired and the officer was shot 8 times that the defendant did not have the intent to shoot and kill this officer to avoid arrest? How can they possibly make that argument?
They can. They have to make that argument. And they're not trying to get him out of a conviction for the death. They're trying to get him out of the death penalty. And I think really the number of shots is more about the aggravation for purposes of the death penalty. What they're going to have to try to say is that he thought that something was going to happen to him. He thought that he was trying to protect himself from this officer. And I think it's really, really hard for them to be able to do that defense with that number of shots.
All right, Latonia Hines, who's joining us today with her expertise. We're going to take a short break and be right back. So that was testimony from another officer who responded to the scene, and one of the things that was significant in that testimony is that he said, listen, if you can't reach another officer on the shoulder mic, then it tells you something is, and I wrote it down, really, really bad. And so one of the things that we've heard testimony that's really important in this case to find Bolton was the police officers couldn't find him. They didn't know where he was. He'd been on an alarm call, and then he disconnected from that. And one of the reasons they found him is because the citizen that previously testified actually used his shoulder mic to say, hey, you got an officer down. So I'd like to return to my guest today, Latonia Hines from Atlanta, who is a prosecutor there. I'd like to turn to you now and talk about some of the elements. Why is it important, or is it important, that the prosecution presents every officer that responded to the scene?
It's all about this timeline, and it's so important. I can't even begin to explain how important it was, especially when that jury hears that this officer is down and that a citizen had to get on the radio. Every officer tells about how they encounter and they get here and how horrific the scene is. Remember the testimony. He said that when he moved, when one of the officers moved Bolton, his face, part of his face moved. He was shot and injured so badly that he was almost unrecognizable. And that's huge. That makes it less likely that this was a self-defense as much as you really intended for this person to die. Because not only did you shoot one time, you shot twice, 2, 3, 4, 5, 6, 7, and we keep going up. And it was such a heinous way to die.
So also joining us is Misty Marris, who is a Law and Crime host and legal analyst, but also a local trial attorney. So tell me about, in terms of the self-defense claim, if they try to assert that, doesn't that mean that he would have had to have used reasonable force and not deadly force, or not?
Right, and that's what's going to be the problem. And also there's another issue here, Ashley, and the issue is that this was a police officer in an arrest scenario. So it's a little different than two civilians confronting each other in a situation where one person feels that their life is at risk. Now you're talking about a police officer using force that is permissible, theoretically, under the law to make an arrest. So that's another hurdle. That's why our discussion before, what we were talking about, why it's so important to know the circumstances behind being pulled over, being taken out of the car, because from a defense perspective, you're going to want to say, if you can, then, if the facts permit you, that there was excessive force there. And from the police officer's perspective, without alienating the jury, because you've got a victim, a horrific circumstance here, but you're going to want to say there was excessive force. So in response, the defendant's response was reasonable under the circumstances, and that's what it's going to be. It is a tough hurdle, but again, remember the goal here: to save the life of their client. I think he's already pled guilty to charges related to this crime, not the murder charge, but they're going to try and save him from the death penalty, and that's the goal throughout this entire trial.
That's right. So let's talk about what he did plead guilty to. In April of 2017, he did plead guilty to the fact that he carjacked an individual to flee the scene, that he was in possession of 9mm ammunition, and he was not supposed to be in possession of that as a convicted felon. And the third thing was brandishing a gun during a carjacking. So those were the three things he's already pled to, and he received 27 years for those. And so he already has a 27-year sentence. And again, an opening defense said, yes, he shot the officer. However, he did not intend to kill him. Now, the other thing the testimony has shown, an opening statement as a prosecution indicates that all of the testimony will show and the evidence will show, is that this car was parked, remember, illegally. It was facing the wrong direction on the road. And that is the reason that the officer even approached the car, just to say, illegally parked, what's going on here? So we're going to take a short break. Please join us as we resume the trial of Tennessee versus Wilbourn. Wow, and that is the moving testimony of the victim's sister. And this is Texas versus Christopher Love. He's been convicted. This is the death penalty phase. I want to bring back in Misty Marris, who is here with us. Tell everyone who's listening and viewing about the death penalty phase and aggravating circumstances that the prosecution has the opportunity to show. Does this particular witness, does this testimony amount to aggravating circumstances?
This testimony doesn't necessarily amount to aggravating circumstances. There's an itemized list in Texas of certain criteria that would be at play. However, victim impact statements are permitted. And don't forget that this is in front of a jury. A jury is making the decision about whether or not the death penalty is going to be the punishment here. Now, sometimes it's a judge. When you have a jury, victim impact statements can go such a long way, especially when you have the heart-wrenching statement that we just saw right now from the victim's sister. So while the loss to the family is certainly one aspect, it might not qualify as an aggravating circumstance. It certainly has an impact on the jury in the course of making their decision.
All right. And so let's remember, too, this is a case in Texas. Texas has one of the highest numbers of death penalty convictions in the nation. And for a short while didn't have the death penalty due to some cases coming down, but now has returned and has that as a possible phase of after a conviction. Now, in Texas, it has to be a unanimous decision by a jury for the death penalty. Now we're going to hear testimony from the victim's mother, who also testified during the death penalty phase. What compelling testimony. That was the victim's mother in the Love case. And Kendra Hatcher was the victim, you may recall, was a dentist, a beautiful young lady. And this mother even said during that testimony you just listened to, can't even call you by your name. For 3 years, we've been calling you the shooter because you executed my daughter. So this was 3 years ago, and she still is as emotional as if this happened yesterday. Not surprisingly, given the horrific random nature of this crime. So Latonia Hines, let me ask you, as a prosecutor, do you think that convictions bring closure to victims' families when a victim's been murdered?
I mean, it's always your hope that it does give them some closure, but in the end, it doesn't bring back their loved one. You hope that maybe they feel that there's some justice that's happened, but it wouldn't matter if it's been 3 years or 30 years. There's something about when you lose a loved one in such a horrific manner, there's some bit that there's not any closure to. There's some bit that you're always going to be, have unrest that your loved one died in such a manner. So at least as a prosecutor, you hope that you've been able to provide some justice in some sense that maybe somebody answered for what happened to this person's loved one, but you know that you can never bring that loved one back for that person.
That's right. And I felt like as she read her victim impact statement, she even felt better by the end to say, I didn't think I could do this, but wow, I did. We're going to take a short break, and then please come back and join us on Law and Crime, continuing to cover live trials.